This is a traditional court, which is the means by which ordinary rural people most often seek access to justice. Gathering in families and local villages, the courts can offer an informal, inexpensive and accessible pathway to justice to more than 17 million South Africans living in these former homeland areas.
We were also trying to talk to the people who were quarreling at their homes and try to make a peace between some of those people.
This woman is testifying in a village court in Limpopo, where a number of members of the village have gathered to form a village council that will decide a dispute. But a controversial new draft bill, the Traditional Courts Bill, introduced by government in 2008, threatens the right to justice of this woman and millions of other rural people if it is passed into law.
The Traditional Courts Bill is a piece of draft legislation that's supposed to address the problem of administration of justice, access to justice in rural areas. It's supposed to replace a piece of legislation that was passed in 1927 called the Black Administration Act. The Traditional Courts Bill is supposed to overhaul that legislation by firstly bringing traditional courts into greater alignment with the Constitution and its values, and then secondly trying to improve the sort of harmonization of the traditional justice system with the state court system.
Currently, customary law occurs in most rural areas where any man from the rural community may participate in asking questions and deliberating over matters that come before their local village court. This allows the community to participate in the making and application of customary law. Traditional courts still function under the Black Administration Act 38 of 1927. This legislation is terribly out of date.
We're challenging the bill because the consequences of the senior traditional leader being the only person forming the court operates to the exclusion of the rest of the community. And in terms of the Constitutional Court, the court has recognized that living customary law is formed by the community. And so in this way, the community would be denied their ability to participate in the formation of living customary law in effective terms. That's the first thing. The second thing is that the Traditional Courts Bill was drafted only in consultation with traditional leaders, whether the National House of Traditional Leaders or traditional leaders at national and provincial level. This is what the memorandum to the bill says. These are the people who were consulted, as well as the South African Local Government Association. But no ordinary people were consulted.
The Law, Race and Gender Unit at the University of Cape Town has been arguing the unconstitutionality of the Traditional Courts Bill and working towards ensuring that ordinary rural people are fully consulted about the bill and their voices taken into account.
Our work in the former homeland areas came out of consultations with women that were living in rural areas. And that's a basic premise of LRG's work, is that we need to take seriously the stories that rural women and other marginalized people are telling about their social and material existence and the struggles that they're undertaking. So part of what we do is legal education, and we see that as a responsibility that we have, and we see that as a service that we can provide. We don't go in and tell people first up that the Traditional Courts Bill is very messed up. What we do is we go in, and our method generally in workshops is to spend a substantial time right up front talking about people's experiences of traditional leadership and governance. We're able to bring people from deeply rural areas into Parliament, and we're able to make that connection with parliamentarians, with legal decision makers, legislative decision makers. We're able to bring these cases right from the ground, right through to the Constitutional Court.
The unit partnered with the Legal Resources Center and local community-based organizations to run a series of workshops around the country in order to consult and educate rural communities on the Traditional Courts Bill. These workshops and empirical research form the foundation of LRG's argument about the problems rural people face before some traditional courts and their concerns with the bill in its current form. At the workshops, a number of rural women spoke about their experiences when dealing with traditional leaders and how unfair practices are being used to exclude them from their rights to justice. From the onset, it was clear to gender activists that this bill would not tackle the key areas needed to remedy the inequalities in traditional courts, but rather threatens to entrench the problems encountered by rural women in their attempts to gain access to justice.
The Traditional Courts Bill in Section 9 says that a husband can represent a wife and a wife can represent a husband, and in fact other members of the family can represent one another in accordance with customary law. Now, anyone who knows anything about customary law will tell you that it is unheard of virtually for a man to be represented by a woman. Even though it suggests that formally women and men are in an equal position, the truth is that they're not, because in accordance with customary law, women would be represented by men, not the other way around.
In terms of the bill, traditional leaders wield more powers without needing to be accountable to their people. In practice, rural people are sometimes refused dispute resolution services if they have not fully paid their levies, and can even have heavy punishment imposed on them for non-payment. This is despite the fact that the Constitution seems quite clear that levying powers cannot be assigned to traditional authorities. The powers given to traditional leaders under the Traditional Courts Bill would enable the situation to worsen.
Now the problem is that in rural areas people don't have official addresses. So when they go and apply for an identity document, they have to go to the tribal office to get a letter stamped vouching that they are a resident of that area. When they apply for pensions, child support grants, even to open a bank account, even to get a car license, they have to get this stamp. And you can't get that stamp unless you're up to date with all your tribal levies.
The bill was withdrawn from the National Assembly in June 2011. Then, on the 13th of December, the Department of Justice publicized its intention to reintroduce the bill in the National Council of Provinces in January 2012. It gave 2 months over Christmas for people to make submissions. The bill was formally reintroduced in the NCOP on 26 January 2012. From here, members of the Select Committee will take it to their provinces for rural consultations. Once the NCOP has made amendments and a decision about the bill will return to the National Assembly. Most rural people remain unaware of the bill's existence. To compensate for the lack of publicity, LRG's rural partners are mobilizing with the support of LRG and its civil society partners to ensure that the people in their provinces are made aware of the bill's content and implications. Ultimately, the Law, Race and Gender Unit and its partners are calling for new legislation to be drafted based on the views and needs expressed by ordinary rural people in the process of their consultation to replace the Traditional Courts Bill.
So the Traditional Courts Bill is patently unconstitutional as it stands. So the content of the bill is problematic. And that's open to constitutional challenge. But then there's another side to it, which is the fact that there's been inadequate public consultation on it. And if that doesn't happen, the Constitutional Court has been very clear that where there's inadequate consultation, the resultant legislation will be unconstitutional. They're going to have to go back and start again. Our position would be that they should rather start again now than to go through all of that litigation only to be told in the Constitutional Court, as they undoubtedly will be, that the process has been inadequate.